Welcome to Shareholder Primacy from Free Float Media, a podcast about activist investing, securities law, and all the ways the financial and legal worlds intersect and collide in real life. Together with Ann Lipton, a law professor at Tulane in New Orleans. She teaches and researches securities and business law. She holds up the legal end of the podcast.
And that's Mike Levin, an activist investor who lives and works in Chicago. He covers the financial side of our podcast.
Yes, I make my best effort. This week, Ann, let's talk about Texas. Yeehaw! How about it? Yahoo! Or something like that. I don't know. It's probably not very effective. What is going on down there? There's a lot of action.
Yeah,
right?
There's some interesting dimensions to what Texas wants to do to compete with Delaware as the preferred home for business
or preferred legal domicile.
Yeah, sort of.
Yeah. Before we get into that, let's talk about our new email address.
Yes.
What is it, Ann?
Yes, okay. If you would like us to talk about something on the show or answer questions, you should email us at shareholderprimacy@freefloat.llc. And in fact, today's show was inspired by one question that we got, and we will go through the mailbag as we can.
Yes.
So,
all right. So shareholderprimacy@freefloat.llc. Send us your questions, your comments, your suggestions, your complaints. Anyway, as Ann alluded to, we got some listener questions, and somebody asked us about, again, what's kind of the legislative and legal environment in Texas, which has been kind of competing to try to win the hearts and minds of boards of directors to domicile there. And in particular, and we'll get into the detail in a moment, they adopted a new law that governs shareholder proposals. There's a lot of other laws pending. We're going to touch on them, but the one we want to spend a little bit of time on has to do with the precatory proposals, the ESG stuff that shareholders are always proposing at the companies. Our listener asked us to talk about it, what the law is, which companies it applies to, because it's not just Texas domiciled ones, as it turns out, whether this new law that Texas just approved, and we'll get the status of it in a minute, whether that violates federal law, all that sort of thing. So what's going on in Texas, Ann?
Okay. So, and I'm actually, as you said, I'm going to expand past just the proposal rule because of their other legislation as well. There's a second bill currently pending, actually, about proxy advisors that raises the same issue. So I think these two bills together, the proposal one, which actually passed, and the proxy one that's pending, actually represent a much greater threat to Delaware's dominance than anything we've talked about so far. So in past shows, we've talked about how some companies have gotten frustrated with Delaware because they think it's too strict, meaning they think courts are too quick to find that boards breach their fiduciary duties to shareholders, and they think courts have made it too easy for shareholders to sue. So Nevada and Texas have been busy trying to capitalize on this dissatisfaction with Delaware to make their states more attractive. And by more attractive, I mean make it nearly impossible for shareholders to bring lawsuits. And then Delaware revised its law. We talked about that on a show. To also make shareholder lawsuits, make these lawsuits really impossible to bring. But now Texas is challenging Delaware in another much more fundamental way. It's challenging the internal affairs doctrine. And that's a much bigger corporate governance earthquake than the legislation on fiduciary.
So we for a moment, and there's going to be some of our followers that know this already, but a lot probably don't. What do we mean about the internal affairs doctrine?
Okay, great. So whenever we have these conversations about Delaware law versus Texas law, we're implicitly assuming the internal affairs doctrine. The internal affairs doctrine is the rule that says, if I'm a company incorporated in Delaware, organized in Delaware, then Delaware law controls my corporate governance. Delaware dictates the power of the board. Delaware dictates the rights of shareholder. It dictates whether shareholders can sue and so forth. Now, if you think about it, that's sort of a strange and unique rule. Imagine a company that does all of its business in Michigan. Its headquarters are in Michigan. The board meets in Michigan. All the assets and the employees are in Michigan.
So it's plants, it's manufacturing, everything. It's within the borders of the state of Michigan.
But if that company is incorporated in Delaware, then when it comes to the question of board powers and shareholder rights, Delaware law controls. And that's weird. It's kind of a unique
Yeah.
system. It doesn't apply to any other area of law. So like normally if your employees are in Michigan, Michigan law applies to your employees.
Oh,
Your
sure.
factories
Like
are-
if there's some sort of employment dispute
exactly that
at the
would
state
Michigan law.
level, right? Michigan law would prevail. But
Exactly.
but when it comes to shareholders and shareholders in the board or whatever, using your example, it would be Delaware law that prevails
Yeah.
because the company elected to basically domicile in Delaware.
Incorporate.
Okay.
Exactly. With one little exception, which will matter in a moment. But if the CEO of the company sells stock to investors in Michigan and lies, that's not considered internal affairs. That's
Okay.
just fraud, and Michigan law will apply to that.
Or
fraud.
Michigan securities law, right?
Yeah,
Assuming
right,
it's not
exactly.
federal law. Yeah.
Exactly. But the rights of shareholders and fiduciary obligations, once you actually have your shares, that's going to be the state where the company is organized, even if all of its business is somewhere else.
Got it.
So that's the internal affairs doctrine.
Right. And the internal affairs doctrine is sort of an idea. It's not like there's some part of like federal code or some sort of state code or something like that.
Yeah, that is actually a more complicated question.
Okay.
But so the thing about the internal affairs doctrine is it's sort of a historical accident. It kind of grew up as a matter of history, and it's not really well thought out. But in general today, people say that it's justified for a couple of reasons. The first is like shareholders easily sell their shares, and they sell their shares across state lines. And if you kind of reorganize what law applied to the company every time somebody sold their shares, that wouldn't make any sense. And the other reason that we have it these days is we analogize to a contract. The idea that shareholders are sort of in a contract with the board and the company and with other shareholders, and they've chosen by organizing in a particular jurisdiction to have their contract governed by the law of the state of incorporation.
Right. So if there's parts of the contract that are unclear or ambiguous, or there's conflict, and you need to sue and one party needs to sue each other, you've elected to, in this case, to be able to do it in Delaware. But importantly, like I said, there's not some part of like federal code or SEC regulation that says that's entitled internal affairs doctrine. It's
That's not exactly true. See,
Okay.
that's the thing. See, Delaware, and this is why it gets interesting, because Delaware would actually say that it is required as an
Oh, right. Right. But all right, cool. Well, let's and this exists why? Why do we care about
Well,
that?
exactly that. It's because of this idea that it would be just too much of a pain to figure out what shareholder rights were if shareholders could sell their shares and suddenly they have a whole new set of rights. And also this contractual idea that the shareholders have, by buying into a company organized in Delaware, you sort of agreed to be bound by Delaware law.
Cool. All right. And then I started hinting at it, and you started to set me straight about the relationship of federal statute and I suppose regulation to all this. And federal law does not, I mean, I would assume that federal law somehow prevails here. Maybe not.
Right. Well, I mean, yeah, exactly. So whether or not federal law recognizes the internal affairs doctrine is actually a sort of complicated question. But what is, and we'll definitely get there. But certainly federal law always beats state law if there's a particular issue. Like, so if state law has a particular rule and federal law has a different rule that conflicts with state law, federal law wins. I mean, that part is in the Constitution.
Right. That's
So
that's right. There's
Right.
the Constitution does that. Okay, go ahead.
Exactly. So the internal affairs doctrine is about how do you choose among the states? Like, is it Delaware law or is it Michigan law? But if there's a federal law principle that conflicts, then the federal law is the one that wins, and that's usually the federal securities laws we're talking about. The federal securities laws, if it has a rule that conflicts with the state law, then the federal law is going to control. But a lot of federal securities laws, especially, usually try to make space for the internal affairs doctrine. Like usually, the SEC kind of makes rules, and Congress legislates around the internal affairs doctrine on the idea that corporate governance is really a state matter. So federal law can preempt state law. But usually they leave a lot of space for state law to do a lot of the corporate governance work.
So federal law is allowed to, but the federal lawmakers and regulation writers tend to be relatively careful. They're all as familiar with internal affairs doctrine, they may not call it exactly that, and sort of respect that, I think is what you're trying to say.
They try not to tread too far into the areas that are controlled by states for corporate governance. And the internal affairs doctrine is central to how Delaware has been dominant for so long in like the market for corporate charters, because to be governed by Delaware law, all you have to do is file paperwork in Delaware. You can have your operations, your stockholders anywhere else in the country, but if you file the paperwork in Delaware and pay Delaware's fees, you're organized in Delaware and Delaware controls your governance. So if you imagine like a different rule, like let's say the rule where your headquarters dictates your corporate governance law. Delaware would never control anything.
No, Delaware has got one company, DuPont,
exactly. And a bunch
of chicken farms and stuff.
Exactly.
Yeah, right.
It's a tiny state. It's a pain in the ass to get to. Most companies wouldn't choose to have their headquarters in Delaware just because it's not convenient. So if that were the rule, that the state of your headquarters controls your governance, then companies would be much more likely to choose a state that made sense for operational reasons. So Delaware needs the internal affairs doctrine in order to maintain its role in corporate governance. And that is what Texas has begun to challenge.
Well, I have another example for you.
Yeah.
Suppose you elect to be traded on an exchange that's based in Texas.
Well, that is not supposed to until now. The exchanges, by the way, that is just, those are regulated federally. That's a whole separate issue. But that's exactly the idea, though, that Texas is doing this, that it has begun to start to try to regulate corporate governance, even for companies that are not organized in Texas, based on other bases. And one of those pieces of legislation is this shareholder proposal rule that we got.
Let's talk about that. Can we delve in for a moment about what that law basically provides for?
Yeah. So so it's about shareholder proposals. Now, to understand this, we have to talk a little bit about what the federal rule is. So obviously we know, we've talked several times about shareholder proposals, and there's a federal rule, 14A8, that allows shareholders to include items on a corporate proxy ballot for all the other shareholders to vote on. They'll make a proposal that the company should report on its efforts to reduce carbon emissions, or its diversity efforts, or its governance stuff. Right. The company should separate chair and CEO. And this federal rule, 14A8, has these procedural requirements about which shareholders can make proposals. They have to have certain minimum dollar amounts in their holdings, that kind of thing. But if they meet the requirements, then when a company sends out a proxy statement with items for a shareholder vote, the company has to include the shareholder's proposal.
In the proxy statement?
In the proxy statement, and let shareholders vote on it. Well, Texas just passed a law that says that companies can, if they want to, choose to raise the minimum holding requirements above what federal law has. They can do that either by amending their bylaws or by amending their charter. And they can set the minimum holding for a shareholder proposal at either $1 million or 3% of the outstanding shares, which for a publicly traded company would be billions of dollars.
It could be, for like Tesla, numbers. Which is the one everyone wants to, is the newest Texas corporation that's few shareholders other than the big three could do.
Yeah, so these are very big numbers, obviously. So very few shareholders would meet this minimum, which would mean that if Texas's law, which passed, it's law now, means very few. If a company chooses to opt in, very few shareholders would be able to make proposals. And the company also says, and the law also says that companies can forbid shareholder proposals unless the shareholders who make them solicit 67% of the votes, which I'm honestly not exactly sure what that means, but we'll leave it at the companies can choose to require that shareholders offer proposals have these
comment on it in a minute. Yeah, okay. All right, so just go ahead. I'm sorry, Ann, I don't want to interrupt you because I have a comment,
but I was just going to say, it's who the law applies to that's the critical thing. It applies, according to the statute, it applies to companies that are either listed on the Texas Stock Exchange, which you hinted at.
Which is this new, just for everybody, that's a new stock exchange. That is actually, I have a little bit of rooting interest in it because it's the old Chicago Stock Exchange that got uprooted from Chicago. It's owned by NYSE right now. It got uprooted and moved to, I think, Dallas.
Yeah, but
and so now that's the new Texas, and they're looking for listings.
Yeah, there's nothing on it right now. So this law only applies to companies that are listed on the Texas Stock Exchange, except that's a null set. There aren't any yet.
Right.
But it also applies to companies with their headquarters in Texas, not organized in Texas, but with their headquarters in Texas. So yes, Tesla applies.
So headquarters in Texas could, and again, there's no, I don't think, and this is when I was kind of looking at this to get prepared to talk about this, there's no, I think, really clear legal standards or doctrine or whatever about what it means to have a headquarters somewhere, is there?
No, that would very often there isn't much of a debate, but you could theoretically go fight about it.
Like a firm I used to work at, Accenture. I when I was at Arthur Andersen, it's a very long story, not enough for today. But Accenture is a classic example, publicly held company. I'm pretty sure it's a Delaware corporation. Probably. They're like all over the place, trying to figure out where their headquarters is. Yeah. Is really hard. Is it where the CEO keeps a desk? Well, he keeps desks in 6 different offices.
Yeah,
I think.
Yeah.
So
there isn't a clear. Yeah, it's a facts and circumstances kind of thing usually.
Okay, interesting. I have a couple of quick comments or questions about the proposal that I think will set up
this
some
one passed. It's not.
That's the first question. The status of it is that the legislature approved it. Governor Abbott signed it like over the weekend or last week or something, right? Mm-hmm. And it also for a company to take advantage of it, I think you have to amend bylaws or charter,
you have
right?
to amend your bylaw or your charter. It's easier to amend bylaws, so you imagine.
But it's not like you automatically qualify, even if you're traded on this exchange with no shares on it, no listings, or you're headquartered there. You have to affirmatively go amend the bylaws.
Exactly.
Or the charter.
And you have to notify shareholders that you're doing it. Yes.
Right. And Tesla, I think, already did that.
Well, they did that for a different legislation about derivative.
Oh, they did?
Lawsuits.
Oh, okay. Never mind.
I don't know if they've done this one yet.
I'm not sure either. Okay, cool. And just to be clear, and we're going to talk about this a little more, the 14A8 federal requirement that basically, if you're a shareholder that kind of qualifies, if you've got the right number of shares and so forth, that requires a company to include your proposal, subject to some limits, on the company's proxy materials.
Yes.
So that's like a publicity thing. So that basically allows a proponent to disseminate their proposal, to all the shareholders and so forth, okay? And then implicitly, the company is then required to include your proposal on the meeting agenda for the AGM where it's going to be voted. Because just by definition, if it's going to be in the proxy, it's got to be on the meeting agenda. Mm-hmm. My sense is that the proposal law that we're talking about that is related to the Internal Affairs Document doesn't really have anything to do with the proxy statement. It's all about whether you have enough shares to even be on the meeting agenda. Okay,
no,
help me
not
here.
Exactly right. Because under the federal rule, if you meet the requirements, you have to. That has to come for a vote. Like you have to let the shareholders come to a vote, and that's what the federal rule is. Right. But the problem is that the Texas law obviously conflicts with the federal law, and that the federal law, the holding requirements for how many shares you have to have are much, much lower. So Texas, if a company chooses to opt in and changes its bylaw, changes its charter, it can set the threshold for what the holding requirements are for a shareholder at much higher, to the point where essentially no shareholder would ever meet it. Right. But here's the thing. The federal rule, 14A8, the right for shareholders to include proposals on the company proxy, normally federal beats state. We just said that. Except 14A8, the SEC created that right in order to allow shareholders to exercise the powers they ordinarily have under state law. So the whole theory behind 14A8 is that once upon a time, companies weren't widely traded, they were all closely held, and shareholders all went to the shareholder meeting. And once they were there, if they had something they wanted to propose, they could stand up and be recognized by the chair and make their proposal and have people vote on it. Right. When shareholders became widespread and everyone started voting by proxy, they implicitly lost that ability, because even if you did go to the meeting, you'd be the only one there. Like there's no way
and the company would hold all the proxies.
Right.
Hold all the voting power. Right.
Exactly. So the whole point of 14A8 was to restore to shareholders to the position that they were in before shareholder became widespread. It's essentially allow them to exercise the rights that they already have under state law. It's right there in the rule itself. One reason that companies can exclude a proposal is if the proposal is not appropriate for shareholder action under state law. So the SEC put some additional bells and whistle on it, their own holding requirements. That's basically about trying to avoid having the proxy become overcrowded. But mainly, 14A8 is supposed to track what shareholders can do under state law. So the implication of that is, if state law doesn't allow shareholders to make proposals under certain circumstances, then you wouldn't be able to use 14A8 for that. But that just begs the question, which state's law?
Right. Yeah. Yes, exactly.
Because traditionally, it would be the law of the organizing state. If you're chartered in Delaware, we look to Delaware's law to decide if the shareholder can make a proposal. That's what Texas is challenging. Texas's law assumes that it has the right to let companies limit shareholder proposals, even if they aren't incorporated in Texas, based on whether they either have Texas headquarters, which, as you say, is not a precise thing, or a Texas Stock Exchange listing, which doesn't exist yet. So the argument that Texas law is making, in a way, is that our law for certain companies should govern even if the company is formally organized in Delaware. So this is a huge challenge to Delaware.
Right. Well, because basically Texas is saying you don't have to change your domicile the way Texas did. You don't have to go and because changing domicile requires a big shareholder vote. Then you have to amend the charter, especially in Delaware.
Yeah.
Okay. For a Delaware company to move out of Delaware, the only ones we read about all this noise about companies leaving Delaware. If you look at the numbers, it's not that many, and the ones that have are all controlled.
Right.
It's all owners or shareholders that had enough votes they could change the charter on their own. They didn't need a shareholder vote. What I'm hearing you say is that Texas has at least attempted here. I'm sure this is going to get well litigated.
Well, it's complicated.
Texas is basically saying you don't have to re-domicile to Texas. You can still avail yourself of this shareholder proposal.
That's
what they're asserting.
They're claiming that Texas has the right to control your internal governance even if you're not domiciled in Delaware, as long as you have sufficient connections to Texas. And the connections it's defined are Texas headquarters and listing on the Texas Stock Exchange.
Wow.
But there is a wrinkle, because as you said, companies have to opt in by charter amendment or bylaw. It is very possible that Delaware would allow that too. Delaware hasn't actually passed a law about it, but I think it's very likely that if you put in your charter that shareholder proposals were limited, then that would control over 14A8. And it's also possible that they would recognize it as a bylaw. I think with the bylaw it's less certain, but it's certainly for a charter. So if that's right, there really isn't a direct confrontation with Texas, because let's say there's a company that's incorporated in Delaware but headquartered in Texas. If it adopts Texas's rule, I'm raising the threshold to 3%, and someone were to sue, a court would say, well, it doesn't matter if you apply Texas law or Delaware law. The outcome is the same. The bylaw is valid because Delaware
because you amended the Delaware bylaws to...
Exactly. So either way, though, I still think conceptually this is a shot across the bow at Delaware. And I should mention the original version of the bill before it passed, it actually was limited to companies that were organized in Texas, that had a Texas charter. They took that out. So this was a real
there was an amendment or something midstream. Okay.
In the drafting. So they really made this deliberate choice that they were going to try to regulate the internal governance of companies that aren't organized in Texas.
Wow. All right. Hey, we should talk about how this applies to other kinds of shareholder proposals. I have some other questions. There's some ways that activists might be thinking about this, and then we can also talk about proxy advisors. But let's talk about all that after a quick break, may we?
Okay.
All right, let's do that. So we will take that quick break now and talk more about Texas here at Shareholder Primacy.
Shareholder Primacy is brought to you by FreeFlowAnalytics.com, the only free database of corporate directors, their influence, and their performance. If you own a stock or retirement plan, go to FreeFlowAnalytics.com and look up which of your elected directors are performing well and which aren't. Use your vote in the alternative democracy and get your data at FreeFlowAnalytics.com. Now, back to the show.
Welcome back to Shareholder Primacy. I'm Ann Lipton here with Mike Levin. We've been talking about Texas and the moves it's made to try to compete with Delaware. So we were talking about the shareholder proposal rule.
Yes, and I think we kind of thoroughly treated the idea of how the conventional kind of E&S proposals, climate and so forth, might be hampered. I think it would be a mild word for it under this, especially if, companies figure out a way to incorporate in Delaware but operate in Texas and then have this 3% requirement. There will be many, many fewer ESG proposals that would have at least gone under the conventional 14A8 route that, where there's hundreds and hundreds of proposals that have been submitted over recent years, but somewhat fewer in the last year or two. What's going to happen for other types of proposals? And I have two types in mind that don't go through this conventional 14A8 SEC no action path. The first, and we don't have to talk about them individually, but I think it illustrates it. The first was the really notable situation when the United Mine Workers, we've talked about this on a previous, at least one other podcast. The United Mine Workers submitted, 4 or 5 proposals at Warrior Met Coal, happens to be a Texas company, and was able to get those proposals, but they didn't use 14A8. They basically treated it like a proxy solicitation and did their own solicitation and so forth and got a bunch of proposals passed. So that's the first one. The second would be a good example would be one that I tried last year, having to do with the bylaw amendments, having to do with shareholder approval of director comp. And if you remember, I submitted a dozen proposals. They happened to go under 14A, but these were bylaw amendments. These weren't precatory proposals. These were binding proposals on the company. If the shareholders approved them, they'd be law. So these type of, outside the normal ESG 14A8 process, what does Texas's law think about? What do we think Texas's law would think about those?
It's the exact same rule.
Really?
Yes, it's the exact same rule. So assuming, again, Texas law controls here, although once again, I'm not sure that it's different than Delaware law in this respect. I think it's very possible Delaware law would also recognize certainly a change in the charter and possibly change the bylaws that limit shareholders. But yeah, under Texas law, it doesn't matter. If it's a shareholder proposal, they're not talking about 14A8. They're just saying that that it is not a proper action under their law for shareholders to bring anything to the floor unless if the company has opted in to raising the numerical threshold, except director elections. Like this doesn't, like it says so in the law. Like if somebody actually ran a director proxy contest.
Oh, so in a proxy contest, this doesn't apply.
It would not apply to that.
Or
but
what I call a proxy
else,
contest.
Like I think a director proxy. It says
for director elections.
But, but if you ran your, exactly what the United Mine Workers did with the
it was like governance proposals and a labor relations proposal. Yeah,
that would all Texas's law says it cannot. You cannot get a shareholder vote on that if the company is headquartered in Texas or on a Texas stock exchange and has opted in by raising the numerical threshold. It's not that you can. It's just that you'd either have to hold $1 million worth of stock or 3% of the company's stock, which certainly most normal people. But for real, serious activists, the $1 million holding might not.
Oh, wait a second. We can talk about that. Is that for a good example of a shareholder proposal from last year was Starboard Capital at Starboard Value at News Corp when they wanted them to declass the board, or not declass the board to. Take away the dual class shares.
No, right, yes. Take away
they're big enough that I'm not sure they own 3%, but they could have, if this was important enough, they could have easily accumulated 3% of that company, and this would not have mattered to them.
Right, exactly, yeah. So it's going to leave out most of, and I don't know how much United Mine Workers owned of Warrior Met, but very possibly
not much. Not 3%.
No, not 3%, but it's or $1 million. And because these statutes seem to,
is it the lower or the greater of 3%?
It doesn't say.
Oh, no? Oh, great.
Because these are all very poorly drafted statutes.
Okay.
Assuming it's the lower, United Mine Workers would probably be fine.
So all the shareholder proposals for the bylaw amendment on the director comp, again, that I submitted, assuming that they were a Texas company, I would have... if I wanted to solicit proxies myself, forgetting 14A8, I don't care about the company's proxy statement. I'm not asking me on the company's proxy statement. I'm going to do all the solicitation by myself, and I'm going to pay that kind of money. That would all I couldn't do it unless I own 3%.
According to the way the statute's drafted, although, as I
Right.
just said, like it's not even clear on the lesser or greater. For all I know,
my
it would be
God.
interpreted by a court differently. But the way it's drafted now, any shareholder proposal that isn't a director nomination.
Right. And then we're subject to this additional requirement. Let's suppose we have 3%. And let's suppose I wanted to do the 14A8 route. I mean, let's say I got, the right ownership requirement. It's a Texas company. And I was trying to use 1480. I was trying to use the company's proxy to communicate my material. I would still be subject to this 2/3 solicitation?
Well, that exactly is another place where the statute, as I said, I don't understand it. It's just this is passed in a rush to make a point rather than as serious, rather than thinking about it seriously.
Yeah.
So it says that you have to solicit 67% of the vote. It says, once again, the company has to opt in. If the company opts in, then any shareholder who wants to make a proposal has to solicit 67% of the voting power. But
Right.
it's not clear whether if it being on the company proxy counts. Like anyone who puts their proposal on the
interesting.
company proxy is necessarily soliciting 100%
Right.
of
You're
the voting
soliciting
power.
100. Exactly. You're soliciting
So
every,
I have
every
no
share.
idea what it means because they didn't tell me.
Okay, but that would be, I mean,
That would make it
this
kind
is
of pointless. So a
Right.
court might interpret it differently, but I don't know because they did.
now this is clearly aimed at ESG proponents. I mean, there's based on what we've talked about and based on what I was able to see is that again, the big time kind of badass financial hedge fund activists and so forth, they're not filing many proposals. There's probably other things that Texas is trying to do to make life hard for them. But the shareholder proposal law seems to be more. I would guess that probably Exxon probably.
Yeah.
has something to do
I
with this.
definitely think that's what they're thinking. And Exxon is headquartered in Texas, so
Right.
but
This
but
is like
it's
an
not-
Exxon Tesla bill, not like
It's not particularly well. Yeah, but this is not precision drafting.
Right. Okay. And well, we could talk about this in a minute, but I wanted to ask you more about this other bill that they're trying to move around
Yeah.
proxy advisors.
Yeah.
But trying to figure out what Texas is trying to accomplish here. Are they trying to get people to list on this exchange? Are they trying to get people to put a headquarters there or put two employees
Or
and
they
call
just
it a
trying to
headquarters?
protect. Like maybe that's why they took out the organized in Texas piece because they wanted it to apply to Exxon. I don't know.
Right. Anyway, so there's another bill,
Yes.
right, about proxy advisors.
Yes.
What's that trying to do?
Okay, so first of all, I'll just say, obviously, because we just talked about this on our very
Yes,
last
right.
show, that proxy advisors are hired by shareholders to help guide how they vote on corporate matters, and they've been getting a lot of hate from, honestly, Republicans.
Well, yeah, for decades now, but yes.
Yeah, and partly that's because they recommend that shareholders vote in favor of ESG proposals sometimes, or at least that's
Yes.
the hook. But we
Right.
said this on the show last time. You said that it's not necessarily about ESG so much as it is that some don't like the fact that they'll recommend against CEO pay.
Yeah, right. That's
Things like
really
that.
that's really kind of it hits them where it counts.
Yeah. I think
But yeah.
proxy advisors help shareholders coordinate their votes. They facilitate the exercise of shareholder power, and that makes them a target. So
Right. Yeah. Exactly. I've long thought that basically going after proxy advisors is just a way to go after their clients, and
Yes.
proxy advisors are just a convenient punching bag.
Yeah.
So anyway,
so
Texas
I
decided
think that's
to
exactly
punch.
right. But there's this legislation, and I'll just say it passed the Texas Senate, and we are now recording. I'm going to mention this on the morning of May 27th, and I'm mentioning that because this is the last day of the House's legislative session, as I understand it.
Oh,
so it's
and
on
Texas
the calendar.
meets like 2 weeks every 2 years or something. So this is it.
Well, it's on the calendar for today. So when this actually airs, it will be either passed or not passed. But I think they can hold special sessions if they need to. Like even if it doesn't pass, I don't know that it's dead forever. It can come back. So it may or may not be law by tomorrow. But but it's still worth talking about just to see what they're doing, even if it doesn't end up passing. And like the shareholder proposal one, it's really badly drafted, really badly. Like one of the things that drives me crazy is that it has this definitional section, which is true of any legislation. It starts with, I'm going to define my terms.
Yes.
So it defines a bunch of terms, and then it doesn't use the terms. It uses different terms.
Oh, it uses a bunch of.
That's
They,
how poorly
forgot
it's
about
drafted. Anyway, so it's really badly drafted. So this bill starts out, so you have to understand how it starts out by saying that it's going to define any proxy advice that's as not solely in shareholders' financial interest if that proxy advice is based on ESG or DEI. Now we've
So
talked
just
about,
by definition, it's
like
an assumption
definitional.
or a premise that
the
anything
premise is exactly
along those
that
lines is not in shareholder interest.
It's not their financial interest. It's not in shareholders'
Financial
financial interest if it's based in any way on ESG or DEI. Now, obviously, that's ridiculous. Climate change can be a very serious financial concern. The G in ESG stands for governance. Corporate governance is obviously a financial concern. But
I mean, empirically, there's lots of debate about the extent and nature of the impact, and there's analyses that show that it's negligible, and there's analyses that show that it's significant. But just assuming it away is not the way to go.
Exactly. Like to think that like you're necessarily not basing your advice on financial concerns if you're worried about corporate governance is ridiculous. So the legislation says if the recommendation includes an ESG or DEI consideration, then it's definitionally not solely in shareholders' financial interest. And then it also says if there's a shareholder proposal of some kind and the proxy advisor is recommend voting against management recommendations, which basically means voting in favor of the proposal.
Yes.
If the proxy advisor doesn't include a detailed written economic analysis, that also counts as a recommendation that's not in the shareholder's financial interest. So there are two types of things that are defined just by definition to not be solely in shareholders' financial interest. Either using ESG or DEI, or recommending in favor of a shareholder proposal without a written economic analysis. So you can already see they're sticking this non-financial label on these recommendations, but at bottom, it's really just about stigmatizing anything that would challenge management.
Right.
And so anyway, if you're a proxy advisor, Glass Lewis or ISS, and you make a non-financial recommendation under this rule, you have to say in your recommendation that you aren't solely concerned about shareholders' financial interests. You have to put a note on your website that says your recommendations are not based solely on shareholders' financial interests. And you have to give a copy of your advice to the company. And
well, they already do the latter.
I think that it's an advanced copy. But there's more. If you give two different shareholders different recommendations, and that happens all the time because shareholders have their own voting policies.
Because they have different policies.
Exactly.
Sure.
If you give two different shareholders different voting recommendations, then if the client that you're giving the recommendations to haven't specifically said they want non-financial recommendations, then you also have to make these same disclosures and you have to notify the Attorney General of Texas, Ken Paxton, that you're making different recommendations. And then you have to identify which of the two is the financial one. And if you don't do all of this, that counts as a deceptive trade practice under Texas law.
So you could get like hauled before a Texas court for
exactly.
fraud or something.
And this law applies, and like the proposal rule, it applies whenever the subject company is publicly traded and either organized in Texas or headquartered in Texas. Meaning, this rule would apply to companies that have Texas headquarters but are incorporated in Delaware.
So, all right. So let's say, wow, I'm trying to even just think of an example is hard.
Yeah.
Let's say you've got an investment fund that's let's say it's Fidelity, which is based in Boston.
Okay.
So it's a Massachusetts fund.
Okay.
And they're a subscription. I know they buy ISS. They also buy Glass Lewis. They can afford it. They don't necessarily follow it, but that's what they do. Okay, and they're looking at a Texas company that's headquartered or traded. Is it the same? The same two? Oh, it's only headquartered in this one. It doesn't have to do with the Texas
This one doesn't say
exchange.
anything about these Texas stock exchanges. It's either headquartered
fine. So
in
it's
Texas or
headquartered.
organized.
So it could be ExxonMobil. It could be American Airlines. It could be Tesla. There's Texas
Tesla's organized in Texas, so that's a little different.
But it's also okay. Oh, yes, that's a good point. But the other ones I listed, and Texas is numbered within the top 3 of Fortune 500s. Mm. I mean, there's a lot of companies that are kind of based there. But it has a Delaware corporate charter. Mm-hmm. Okay, so Massachusetts fund buying advice from ISS, which is based in Maryland. I'm not sure that matters. And it's Texas company incorporated in Delaware, this law would mean ISS would have to jump through all those hoops or just give up.
Yes, that is exactly what they propose. So, and I should say, even before we get to the issue of the internal affairs doctrine, I really should note, Missouri adopted a rule very similar to this, but not for proxy advisors. It was for brokers who made recommendations to clients in Missouri, so it was much more territorial.
Oh, sure,
But the brokerage industry challenged the rule, and a court held that the rule violated the First Amendment and was unconstitutionally vague. Yes.
So like a buy-sell was viewed as expression of First Amendment?
Well, it was just having to put this, I am doing non-financial recommendation warnings, was viewed as a violation of the First Amendment and unconstitutionally vague, precisely because, as we've said, it's such a weird label to put on things that might very well be financial. So I'm just throwing out there that this bill, which may or may not be law by the time this episode airs, it may have constitutional speech problems. But putting that aside, from a corporate perspective, the claim that Texas is making, I think, they're calling this a deceptive trade practice. They're claiming it's about fraud. They're trying to protect shareholders from being defrauded. That's what they claim. And I said before, Texas does have the right to regulate fraudulent investment information in Texas. But as your example shows, this statute is purporting
This is like a Maryland company sending a report to someone in Boston.
Exactly. Normally, Texas does not have the right to regulate fraud.
They wouldn't even know it happened.
Yeah, exactly. Honestly, I'm not even sure if it's a Delaware, let's say a Delaware incorporated company, Boston investment fund. I'm not even sure Delaware could regulate this but at least Delaware would have a much better claim because the internal affairs doctrine says if the company is organized in Delaware, then Delaware controls shareholder rights, including the information shareholders receive. In fact, I think Delaware, if we thought of Delaware doing this, it would be on safer ground if it said something like, shareholder vote does not count as fully informed if it doesn't receive the kind of advice.
Okay.
But that would be Delaware regulating a Delaware organized
corporation or a company that opted into Delaware's legal system.
Texas is trying to regulate Delaware organized companies as well by anchoring its legislation around where companies are headquartered. So this is very aggressive.
So this takes us back to where we started, which is the internal, the idea, the internal affairs doctrine, the idea that, companies sort of internal, and by internal we mean kind of, between the company and its state of domicile.
Right.
Texas is kind of invading that.
Yeah, well, it's kind of invading the governance of companies. It's claiming the right to regulate the governance of companies that are not organized in Texas. And this gets back to what you had said before, but the internal affairs doctrine isn't a federal statute or anything, and that's true. Yeah. But Delaware would say, and this is where it gets fuzzy, that the internal affairs doctrine is constitutionally required.
Okay. So there's no specific law, but there's ways to read the U.S. Constitution on parchment.
Yes. that it's actually unconstitutional for Texas to try to control the internal affairs doctrine of a Delaware company. And Delaware gets this from some Supreme Court precedent that sort of supports that.
And U.S. Supreme Court, not like
U.S. Supreme Court. So back in the 80s, when hostile takeovers first were a thing, some states passed anti-takeover legislation that protected companies from hostile takeovers if they were doing business in the state. This legislation, it didn't care about where the companies were chartered. It cared where the company had its headquarters or where they had a lot of operations, where they had a lot of business. And the Supreme Court held that this anti-takeover legislation represented an illegitimate attempt by states to regulate economic activity that took place outside of their own borders.
Oh, interesting.
But then, when states revised their laws and they started adopting anti-takeover legislation that explicitly said it only applied to companies that were incorporated within the state, and then the Supreme Court okayed it. So that was some very specific legislation under some very specific circumstances, but Delaware's kind of run with that very limited precedent to say that the internal affairs doctrine is constitutionally commanded. So that would mean that Texas's laws here, it's not that they conflict with federal law exactly, it's that they are literally unconstitutional. That said, right this second, I'd say we're in a period of constitutional upheaval.
Right. It's not clear whether this current Supreme Court would even consider something.
Yeah, it was already it was already very shaky precedent to begin with. I mean, Delaware had its reasons for claiming that the internal affairs doctrine. It's solid constitutionally. And it really was never that strong to begin with, but there was some precedent for it. But I honestly don't know. If Texas decides to keep running with this, I don't know how this fight shakes out.
Yeah. Wow. Okay. So, and I was going to ask, let's kind of sort of see where this goes, but there's really no way to know at this point.
Yeah. And I mean, I don't even know whether the proxy advisor rule will pass by the time,
Right.
by the time
there's, I saw there were 2 or 3 other bills that there's the one that has to do with derivative lawsuits. There's several here.
Yeah.
And maybe in a few weeks we can do a little wrap up and sort of see what happened in Texas, but importantly, not just what it means for like activists and so forth, but what it means for the law.
Yeah.
To see what their whole collection, with their whole portfolio of legislative changes means in their effort to. I'm not even sure what they're trying to do here. Attract companies' headquarters? No, they got plenty of those. Domicile? No, they just took that off the table. Are they trying to boost this stupid stock exchange? I don't know.
I do not know. It's very possible that you said that the reason they made the shareholder proposal rule not just apply to companies that were organized in Texas was specifically for Exxon.
Right. Yeah. And all right. Well. All right. Cool. Let's. My head hurts. I don't know. Hopefully we'll talk more about Texas in a few weeks or whenever when they have a little more clarity on some of this stuff. All right.
Okay.
All right, let's wrap up. Thanks, Ann. Terrific talking to you about these. I think it's terrific. It certainly is makes you think hard. We'll talk more later. This is Shareholder Primacy, hosted by Ann Lipton and me, Mike Levin. I'm an independent activist investor and advisor to investors about their activist situations. Ann is the Michael M. Fleischman Professor in Business Law and Entrepreneurship at Tulane Law School, and an affiliate of Tulane's Murphy Institute. You can find me, Mike, at theactivistinvestor.com and Ann at law.tulane.edu. Our podcast is produced and distributed by Free Float Media. Thanks for listening. We'll talk again soon.